Hello, welcome to today's immigration tidbit. Well, the answer is yes, it will likely affect the ability to adjust. You have to realize there is a huge difference between an I-130 being approved and the visa number being available in order to be able to adjust. It all depends realistically on what country you're from, but when you have a fourth preference petition, okay, and of course this assumes that it is a sibling petition you're talking about, and it also assumes she's over 21, so I would need to have some clarification there, but assuming those facts, it could take 15 to over 25 years in which a visa number becomes current. So you could file the I-130 as a U.S. citizen brother. It could be approved, 6 months later, a year later, it doesn't really matter. And your sister would not be able to adjust status or to apply to adjust status or consular process for the next 15 to 20 years. The approval of the I-130 itself does not give her the right to stay here in the U.S. legally. It does not change her status to becoming legal. It does not change someone who is here illegally to legal. So it is just one step in the process, and by no means will it allow her to adjust by just waiting here for the next 15 to 20 years. Now, there are things that can be done in order to minimize the problem, but at a minimum, if she hasn't overstayed already for a year and or 6 months even, and is not subject to the 3 or 10-year bar, she should leave. And once it becomes current, she can come back. But there are a lot of other ways that she can obtain legal status here. Non-immigrant work visas, employment-based petitions for the green card. There's all kinds of ways. She doesn't have to do just this. But if this is all that she can do, then if she's not yet out of status and hasn't expired, at least for 180 days, then she needs to leave so she's not subject to the bars and be able to come back legally at some point. Okay.